you want to leave good, smooth sailing atmospheres for the Tooth Fairy. No extra disturbances. Let's see. I think we have everyone at the moment. Let's double check the list. Good morning, Emily. Can we hear you?
Good morning.
Good morning. And Tony, can you do a quick mic check, please?
Yes, ma'am. Good morning. How are you?
We hear you loud and clear. Thank you. And Brett.
You got me?
Sure can. Thank you.
Perfect.
All right. And with that, I will start our recording and we'll get going.
Recording in progress.
Good morning. This is the April 30th, 2026 meeting of the Sexual Assault Response Network Committee. Thanks to everybody for being here. We have another full agenda this morning, and we also need to welcome a new member. I am, for the record, Hope Stockwell, the Sexual Assault Response Network Program Coordinator, and our newest member today is Stephanie Robles. Stephanie is one of our Assistant Attorney Generals. She's joining us to take the position vacated by Celine Kepke. And Celine we thank her very much for her good work with the committee and the program over the last 2 years. She is going into private practice and will be still working, though, with law enforcement and county attorneys in that regard. So we look forward to crossing paths with her in the future. And Stephanie, we start our meetings typically with a round robin of member updates. And I think I'll start with you and just ask you to introduce yourself a little bit for the committee, and committee members, as you take turns, if you'd tell Stephanie a little bit about yourself and maybe your specific role with sexual assault response, and perhaps a highlight for you in the last almost 2 years of work together, something that you'd want her to be sure to know, perhaps starting this work with the group, please. So Stephanie, we'll start with you.
Perfect. Thanks, Hope. And I apologize. I'm having some technical difficulties. I can't get my camera to turn on. I don't know why. But as Hope said, my name is Stephanie Robles. I'm an Assistant Attorney General at the Montana Department of Justice. I'm really thankful for everyone's warm email welcome, and I'm really excited to be a member of this committee. This is a topic that is definitely near and dear to my heart. By way of background, throwing it way back, I started my career in defense work, and I've worked sexual assault cases from a defense perspective. Then I started working for Lewis and Clark County as a prosecutor, and I prosecuted many sex cases at the county level. At that time, I was on the Lewis and Clark multidisciplinary team, working with SARN nurses, child protective services, law enforcement, mental health professionals, and the Child Advocacy Center to prosecute child sexual assault cases. From there, I moved on to the Attorney General's office in 2020. I continued prosecuting primarily child sex cases and homicides. I also helped teach the courtroom portion of the Montana forensic interview training for a number of years. I left the Attorney General's office briefly for a little over a year to work as an assistant United States attorney, and prosecuted child sexual assault cases and facilitated the Fort Peck multidisciplinary team before returning to the Montana Attorney General's office in 2024. Since that time, I've continued to be active in child sexual assault prosecution, and I've gone to jury trial on 3 multi-victim child sex cases just in the last 8 months since I've been back at the Department of Justice. So I'm really hoping to be a resource and a helpful team member with whatever the committee needs by relying on my training and experience, and I look forward to being part of a group that's committed to offender accountability and healing for survivors of sexual assault.
Hope you're muted.
Thanks, Suzanne. So the mute button is with the Tooth Fairy, apparently, today. But Stephanie, thank you for sharing that information, and we appreciate the background that you're bringing to this work. Let's see, I'm going to start in my upper right corner of my screen with Christina. If you'd go next, please.
Hi, and welcome, Stephanie. It sounds like you're going to be a wonderful addition to this team. I'm Christina Powell, and I work for In this capacity, I am the program director for the Sexual Assault Counseling Center, which is Montana's only designated direct service rape crisis center, and also the Gallatin County Child Advocacy Center. And that this team is just filled with such incredible minds that it's really just been a privilege to be part of.
Thanks, Christina. Emily Mangus, you want to go next?
Sure. My name is Emily Mangus. I am the program manager for the forensic nursing program out of Bozeman Health. I would agree with Christina, like this group has a lot of really brilliant minds, and I think we've been able to have some really amazing discussions because of that. And I really love the fact that we are able to listen to each other and come back with like respectful questions and seeking knowledge when we're unsure about maybe what has been said or if we're unclear about things. So that is something that I really have respected this group for.
Thanks, Emily. Whitney?
Hi, my name is Whitney Brothers. I'm the forensic coordinator at St. Peter's Health in Helena. So I run our forensic nurse program. I think just mimicking what everyone has said so far about the committee, I really enjoy being a part of it. It's really brought some light for me to see how the other professionals who interact with these cases differently than a forensic nurse, how they're thinking and what their job is. So that's been really helpful. I'm also excited. You know, we've spent a lot of time over the last almost 2 years thinking about ways to improve the sexual assault response across the state. And I think that there's some exciting things coming up where we actually get to see our work play and roll out throughout the state and how that will impact folks across the state. So welcome to the team.
Jamie.
Good morning. My name is Jamie Bray Tanner. I am the biology section supervisor at the Montana State Crime Lab here in Missoula. Our section processes all of the sexual assault kits and any biological evidence for the state of Montana. We are not just for Missoula, we do work for the entire state in all the major cities. I've really appreciated learning from everyone in this group because we get kind of stuck in our own field and knowing the different steps that it takes to process and that goes into sexual assault investigations. It's just been really eye-opening for me.
Thanks, Jamie. Brenda?
Good morning, everyone. Brenda George, Children's Alliance in Montana. I echo everyone's comments about being part of this committee. It's great. I would like to also add that I appreciate the public, members of the public who have a lot of expertise, who also take time to listen and give comment to us because we found it very valuable. Wanted to do a little shout out to Bridget Nelson and the Billings Clinic for a great medical minute that I've been seeing on TV about the sexual assault program at Billings Clinic. So really great to see that awareness in the community of what we have actually going on here in Billings.
Yeah, that's awesome. I'll have to check that out. Tony, Captain Honeycutt, you are next.
Good morning, everybody. Tony Honeycutt. I'm the captain with the Lewistown Police Department. Been dealing with the local SART team here, the president of the CAC in central Montana. At least for now, I'm fixing to get ousted, which is about time. Got some young blood coming in to help, which is great. Being part of this team is quite an amazing feat. We know what we do from our side and maybe what the attorneys do, but the other pieces that we never really get to play with out here in rural Montana, it's kind of nice to know that everybody else struggles with the same things and that, you know, there's a team of people that are willing to try and change it to make it great for everybody. So welcome to the team.
Thanks, Captain Honeycutt. Brett?
Hi, Stephanie. We know each other because we run in the same circles as prosecutors. Never had the opportunity to try a case with her, maybe one day. Um, yeah, we do a lot of the same stuff. One thing about this team that's been pretty amazing is just getting the different minds from around the state that deal with things that, maybe we think about in a cursory way from a prosecutor's perspective, but to really get the perspectives of each of these individuals and see the challenges that they're facing. And really, I think just the broad, I don't know what the word is there. The purpose of what we're trying to do anyway, and the ultimate conclusion we're trying to reach to come up with some sort of a format, maybe a book to help all those around the state with responding to sexual assaults, I think is just such a worthy goal. And in the interim, working on legislation like some we're talking about today, that I think would greatly benefit our state and wouldn't be possible without all these different minds from all these different backgrounds. So that's been really cool to see.
Thanks, Brett. And Mark.
Hi, Stephanie. Welcome. My name's Mark Horn. I'm the manager of the telemedicine department at Billings Clinic. And I've basically just been in a learning role because I would probably have the least exposure to everything going on. So I've been learning a lot, and I think you'll really enjoy this group. Just great people.
Thanks, Mark. Let's see. And then we have a couple folks from DOJ, in addition to myself, who are here. I want to be sure we hear from this morning. Emily Cantrell, which I know you know, Stephanie, but any words you'd like to offer this morning?
I think I'm good, but yeah, I think all of you guys know I'm the AG's Director of External Affairs, and I did talk to Stephanie earlier this week, and we work together. So yeah, I'm glad she's here and gonna be a part of this work.
Thanks, Emily.
Thanks everybody for the introductions.
Yeah, we are glad to have you. Brenda, I see your hands up there.
Yeah, I'm sorry. I forgot to welcome you, Stephanie. I'm looking forward to working with you again. I've had the pleasure of working with her at the forensic interview training and hearing all the great work she's done in trials for our teams across the state. So glad to have you aboard, Stephanie.
Thanks, Brenda.
Awesome. And then Suzanne?
Yeah, good morning. I'm Suzanne Anders. I am the supervisor of the Office of Victim Services, just rounding out my 10th month. So it's been a lot of catch up for me and just admiration of what the team has done together to get to where we're at.
Thanks, Suzanne. And then we have a couple of members who can't be here this morning. I heard from Jordan Kilby and Sergeant Kara Gadarian and Ben Ulick that they have conflicts today and will not be joining us. Sue Parker is going to be a little late. She has a presentation with the Tribal Health Committee at 9 this morning, so she'll be coming in after that completes. So with that, a couple of updates here from our program. We'll talk more here in a little bit about the Law and Justice Interim Committee meeting that's coming up next week. So we've been staying in touch with their staff about that, making sure they have everything they need for the consideration of the SARN proposal that you all have been working on. And then the following week, May 13 through 15, we have our first joint sexual assault investigations and prosecutions training that we're co-hosting with the Montana Board of Crime Control and the Department of Corrections. It's going to be out at Fort Harrison. We have 92 folks registered right now, about half and half with law enforcement and prosecutors, so really great turnout. And lots of folks who are making that possible with trainers who are coming from national organization to support, and then also Montana prosecutors and law enforcement officers digging in and helping provide information. And so it's really been a great collaborative effort, and we look forward to having everybody together here in Helena. That's really exciting. So With that, let's turn our sights. Does anybody have any questions before we get started, though, today with our first other agenda item on the SARN budget proposal related to forensic exams and SARN programming? Any other comments or questions before we get going? Okay. If you would please pull up so you have it for reference, the draft legislative proposal, which we provided to the Law and Justice Interim Committee at its March meeting, and then they awesomely took that up as potential for consideration as a SARN, or pardon me, a Law and Justice Interim Committee sponsored bill for the 27 session. They are going to be looking at their formal draft that they asked their staffer to put together coming up next week at their May 7 meeting. So the draft that you have in front of you today reflects that formal drafting by their staffer. She has noted the ongoing questions in the draft proposal related to funding sources that we have previously discussed. For instance, would it be state general fund that the bill points to for the necessary funding source? Would it be the marijuana revenue that was discussed in the 2025 session as a possibility? And so that's something that she has pointed to as something that the Law and Justice Interim Committee should decide as it moves forward, and we'll be discussing at their meeting next week on May 7. A couple other changes I want to point out to the draft that have been made since you last saw it. They're very small things. For those in the public, if you have not seen the draft, it is posted on the SARN committee's website right now under the April 30 meeting materials. So you could Google Montana SARN committee and go down to the accordion for the April 30 meeting and find that copy there. So a couple of changes to point out for everyone. On page 1 of the draft, on line 21, the language previously said money in the account shall be used by the Department of Justice only, and then it reiterates what the purposes are, which is in line 22, subsection A, for the purposes provided in Title 44, Chapter 4, Part 17, which is the SARN program, including the training for nurses and law enforcement and prosecutors that we've been talking about. Also then in line 23 and 24, the purchase and distribution of sexual assault evidence kits. And line 25, we talk about the reimbursement of healthcare facilities for the forensic exams. But then in line 27, we have added authority to establish and maintain a secure electronic system. We are still working here to figure out what that looks like and whether we could take something that we already have within our IT portfolio and adapt it for this purpose, or whether we would need something new. And so as I was reading through this again, working with the Law and Justice Interim Committee on the formal draft here, it became apparent that we might not want to say shall be used by the department, because if we don't need to spend money on that electronic invoicing system, then we shouldn't say we shall spend money. And so we switched it to a may, just to give us a little bit more flexibility and clarity that this was an authorization, but not a demand, I guess is the simplest way to put it. The other change that occurred was at the end of the bill. The editors at Legislative Services suggested that the codification instruction be changed. So if you look at the last page on lines 25 and 26, previously when the bill was more narrow and focused on just creating a single payer system for forensic exams, the codification instruction would have put the new language in section 1 next to the existing exam payment statute. However, because the funds can now be more broadly used for all of SARN's purposes, the training, for example, the editors recommended it be codified with the rest of the SARN statutes. And so that's where the new codification instruction is. It's a small detail, doesn't it makes sense, I think, in a housekeeping way. It's not a substantive change, in my opinion, and shouldn't raise any concerns. But those are the highlights there. We did receive through Emily a public comment about a couple of lingering references in statute to the International Association of Forensic Nurses. which has gone defunct recently. Unfortunately, they had some crippling financial problems, and so the organization does not exist anymore. There are two statutory references to it. If you look at page 5 of this bill, and again, thanks to Emily for raising this to me last night, I'll prepare a message for the Law and Justice Interim Committee that those references to that organization should be struck. But if you look at page 5 of the bill draft, the end of line 14, it starts to say guidelines from the International Association of Forensic Nurses, and it repeats that starting on line 18 as well. And so these are references that the original legislation included as it talked about things this committee should consider if it were adopting educational standards for nurse examiners and adopting and implementing evidence-based sexual assault forensic examiner training curriculum, that it wanted this committee to consider that IAFN guideline. Without the IAFN being around, well, simply, I think the easiest thing is to strike the reference to the organization. The preceding language on those lines refers to the national training standards and the national protocol, and I think that is sufficient for what needs to be mentioned here. I don't think we need to replace IAFN, for instance, with another specific organization name, because then you run into these circumstances again, potentially. So I think it's sufficient just to reference those national training standards and national protocols as the basis if you look at those things in your committee work. Any questions, other comments, or thoughts on the bill draft? Yeah, Whitney?
Hope, can you remind us again, we didn't put specific numbers in here for reimbursement. And can you just remind us why we didn't do that? I know you had a reason, I just can't remember.
Yeah, thanks for the question, Whitney. So if you look toward the bottom of page 5, the section that's on that page 5 is 44-4-1703 of the Montana Code annotated, and that lines out this committee's rulemaking authority and duties. And subsection 6 relates to, that starts on line 27 at the bottom of page 5, relates to having you establish and periodically review payment amounts. And so you have rulemaking authority to set those payment amounts and payment structures, what is eligible for coverage within the statutory framework. And because you're interested, for instance, in having that annual CPI adjustment, which is included later in subsection 6, I would not advise putting a specific dollar amount in this statute, because then in order to change it, you have to come back to the legislature and ask for the change, for the amendment. Whereas if you don't specify the dollar amount in statute, then you can use your rulemaking authority here to specify the dollar amount and adjust it as needed based on circumstances that occur over time. So it's just more flexible. There's still a procedural process, the Montana Administrative Procedures Act, that you have to go through to make a rulemaking change. So it's not something that can occur without public notice or in the dead of night. And the statute then would lean on that procedural process for making sure the public is informed and has the chance to comment. They just wouldn't have to go through the legislative process. Other questions or comments? All right. I'll make sure that the Law and Justice Committee has a copy of the letter you submitted to them in March for their meeting next week, just for reference, to be aware of the previous opinions the committee has expressed. If there's not any other discussion on this, I guess the last thing I would say in relation to the budget amounts, that is the other change, pardon me, that is at the end of the bill draft in the appropriations section. You see on page 9, lines 17 and 18, those adjusted budget figures that do represent the suggested exam amounts that you all discussed at your last meeting, which was if an evidence kit is collected, you would recommend a budget that could allow for $1,250 per exam. And if an evidence kit was not collected, you would recommend 850 be paid per exam. Now, that's not set in stone. You all still need to go through your rulemaking process if the legislation passes to establish those amounts, but the budget that's anticipated here with the appropriation language would incorporate those figures and be large enough for those figures. Yeah, Whitney?
And we wrote out specifically somewhere the evidence collection kit part and not necessarily just referenced evidence, correct?
That is something I think, again, that would be specifically stated in the administrative rules that you would consider and adopt that specific language. So it would not be dictated here, but would be dictated in that administrative language. But what we do have, so the administrative rule process has to be within the construct of what the statute says. And if you go back to Section 1, where it authorizes DOJ to spend the money, page 1, line 25, it says to reimburse healthcare facilities for sexual assault medical forensic examinations of victims of alleged incidents of sexual intercourse without consent, sexual assault, or incest. And then you pair that with going back to page 5 and into page 6, the committee's rulemaking language, which says that you establish and periodically review payment amounts, eligible services, and reimbursement processes for sexual assault medical forensic examinations. And then at the top of page 6, it says you shall include an annual adjustment based on any change to the consumer price index from the previous year. So it leaves you wiggle room as a committee when you establish the rules to talk about what the eligible services are and the reimbursement rates for each of those. So you're not locked in to anything, but we did need to anticipate what the budget might be. And the way we anticipated that is building a budget that includes a rate when a kit is collected and when a kit is not collected.
Okay. My thought is just if we specify kit collected, that I think is easier on the person who's working with the portal and the reimbursement, because if we open it up to evidence collection, I think that leaves more room maybe for not confusion, that's not the right word I'm looking at, but for example, sometimes we'll have a patient come in who is reporting sexual assault, but they only want a toxicology kit done. They don't necessarily want the full forensic evidence sexual assault kit done. So in those situations, would the hospital get reimbursed $1,250 or would the hospital get reimbursed $850? Or say maybe a patient comes in, we collect their clothing, but not the sexual assault kit. Is that reimbursed at $1,250 or $850? Maybe doesn't have to be clarified here, but that was a situation that kind of popped into my head and was brought to my attention that I thought I'd ask.
That's the kind of nitty-gritty discussion this committee would need to take up if it anticipates or when it gets to a rulemaking process for implementing a statute, if there's a statute change. Yeah.
Okay, so I'm just kind of jumping the gun a little bit.
No, I think those are conversations that are important still now to be thinking about, because those are going to take time to work through. And so not trying to do them, quickly, suddenly, but having thoughtful conversation is great. So don't feel like you're jumping the gun.
Okay, thanks.
Other questions, comments, discussion? Okay. So we'll go to the public comment portion of our meeting for this topic. We'll now seek public comment specifically on sexual assault forensic exam payment and SARN budget legislative proposal considerations here in front of the committee. If you, as a member of the public, would like to make a comment, please click the raise hand button at the bottom of your screen at this time. And I will ask you to unmute yourself after I give you permission to do so. And if you would please identify yourself and if you represent someone other than yourself. and also spell your name for the record. Give it a second here. Nobody raising their hand to make a comment at this time. I'll give it a last call here. Okay. Any other committee questions or discussion? We'll plan to send an update in email to you all after the Law and Justice Committee meeting next week, and just let you know how it went and where things are headed. And then we can talk as a committee about whether you need to call for a meeting to respond to something from the committee if needed. Okay. Let's see. Our next item is the discussion on minor self-consent to sexual assault care. Do folks want to take a couple minute break? I know Brett has a PowerPoint that he needs to queue up. Go refill the coffee cups and come back ready to get into discussion. Okay, let's take a 5-minute break. We'll come back. Well, we'll just say come back at 10:10 to make it an even number. All right.
Hope I'm going to try to restart my computer and hope I can get my camera working.
Okay, I'll look to readmit you. Thank you.
Thank you.
Yeah, I can do that. Give me 1 second.
Committee on April 30th. And we are moving on to the portion of our agenda related to minor self-consent to sexual assault care. My thanks to Brett for taking on the presentation. And Brett, I'll just turn it over to you to take it away.
Awesome. Thank you, Hope. I appreciate it. So, Celine was originally going to be doing this, and then she decided she needed to leave us. So I took over and put something together here. I would just say, as I go through this, if there's any questions or anybody has thoughts on anything, please speak up. Stephanie, I'm sure you will have some thoughts, so I look forward to hearing what you have to say on the matter. I'm going to go through generally the statutory provisions that would apply to the legislative change that we're proposing here, some case law, and then the constitutional considerations that are really borne out in that case law, and then what that kind of means or could mean for the proposed change that we're looking at implementing here. So with that, I will get started. Can everybody see my PowerPoint? Got it up there? Perfect. All right. So, I thought it would. Goodness gracious. Starting off on a bang here. I wanted to have it's next. That's right. Here we go. All right. So this is essentially our proposed legislation. It regards the validity of a consent of a minor for health services. Specifically, what we're looking to do is give medical professionals the ability to treat a minor when they come in as a victim of a sexual assault without having to give parental consent. We've discussed this language, and I've got some thoughts on it that I'll talk about at the end about maybe tailoring it down some to deal with just the circumstances in which the parent or legal guardian is a suspected perpetrator, which we have in there, but it may be better for us to really tailor it down just for those purposes. And so this isn't obviously the entirety of the statute, but this is the sub E is what we would be looking at making a change to there. I guess before I even get into any of this, does anybody have any thoughts on this proposed legislation at this time before I kind of go through everything else that may affect it?
Brett, just for reference,
Yes.
I didn't include the proposal the committee had previously looked at and discussed in December and then again in February in the meeting materials, but I just shot an email to the group, so you have a link to the latest version of that, which would reflect the language changes you discussed in December. And then for the public's reference, if you go to the SARN committee webpage, you could find the draft under the February 27 meeting materials. It's listed as draft A, minor self-consent for sexual assault care, if folks want to take a look at that. And then I do see two hands raised. Captain Honeycutt.
Thank you. Hope. So, Brett, I'm glad you're doing this. This is something that's needed to be changed for quite some time. We've dealt with this here quite a bit, especially when we talk about like the incest or some of that kind of stuff where the kids aren't protected and the parents are, blocking them. So I'm glad to see you're doing it.
Excellent. Yeah, that's the circumstances that I've seen as well, where I think that this change can be very effective and helpful for minors in that situation. I mean, I think the biggest thing is we don't want a cooling effect on minors to go seek this sort of treatment if they know, hey, my mom and dad are going to find out about it, especially if they're the perpetrator. So yeah, I agree. Yeah, Whitney as well. A hand up.
Two thoughts. One is, when we limit it to parents or guardian or for that incest part, this other situation, there's a couple of situations that come into mind, but one is if this is a sibling on sibling and then parents are maybe non-believing or something like that. That was another situation that has come forward that parental consent was an issue when they wanted to seek medical care following an assault by a sibling, but parents weren't necessarily supportive or believing or like wanting this medical care done. That was one situation that had come up that I know of recently. And then the other one, and I recognize we are all about sexual assault response. We had a situation, because I live in Helena, we have Show Dare here in Helena. We had a provider reach out to us that a patient had disclosed to a provider there that she had bruises on her butt from her parents from physical abuse, and would they didn't want to contact the parents to get consent to do this intimate exam. It was on a weekend. There was confusion with CPS if they would be able to do those exams as well. When I followed up with CPS, they said that they're really not taking intimate photos like that, especially if the like parents aren't consenting to it. And so they had asked if they could come to our hospital, and we kind of fall under that same thing of you need parental consent. So I know we're talking only about sexual assault here, but just keeping in mind for the committee that sometimes physical assault exams are just as important too. So ultimately, I did follow up with them, and that child wasn't able to get those photographs taken. So I think that's really valuable evidence that essentially was lost due to the restrictions related to this. So just throwing this out there.
Yeah, I agree. I think those are two great points. Like you said, I don't know that um, the physical pictures in that instance, but I think that bruises on the butt. I mean, that's potentially sexual assault, right? I mean, that's what we're looking at, and I think that this would allow a SANE exam to be done in that point. Obviously, there's still mandatory reporters. I'll be talking about that with CPS, but I do think that this change would allow that medical professional to conduct an exam without parental consent. I mean, that's really the goal, right? The sibling part is a great point. And, for my purposes today, because we've discussed it before, the similar statutes in surrounding states, as we discussed before, is probably something that we could look at again from that lens to see how they dealt with that sort of situation, because I wasn't looking at them for those purposes necessarily prior to our last discussion on this. But definitely, I think something worth looking into from my perspective. Christina?
So that's so interesting, Brett. So that how at some point you think that we could make a statement towards that effect that hospitals could comfortably and medical providers could comfortably use. I don't know that they would necessarily go bruising. I think correlating bruising on the bottom to sexual assault is a really interesting approach that might open more doors for us.
Yeah, no, I agree. Again, it's always very fact specific. Without knowing the exact facts, I couldn't tell you exactly how that would be, how you could attribute that necessarily. I was just trying to tie it back to, kind of the reasons we're looking for this. And if there was based on, where the bruising is, I mean, could make a difference, obviously. So, without knowing the facts, I wouldn't know how, exactly how that would play out, I guess. But fair point.
Okay.
Brenda?
Yeah, Brett, I was just wondering, with Whitney bringing up the siblings, what if like grandpa's in the home and, so not necessarily, could it be something that would apply to anyone in the home? Just because a kid may not want to disclose or may not, trust, or with one of the parents possibly being the abuser. So just wanted to bring that up. We see that a lot.
Yeah, and how we have it currently written is more broad, and I think would encompass those sorts of situations because it is suspected to be a victim of sexual intercourse without consent, sexual assault, or incest. It's not necessarily with the parent. I mean, the language itself is something obviously we need to further discuss. For today's purposes, I'm really going to be looking more at trying to just inform as to what the law is around it, what the constitutional considerations are around it. And I agree. I think that, the specific language is clearly something we need to continue to discuss and kind of talk through all the different sorts of scenarios that may arise, that may warrant additions or subtractions from whatever language we end up with. I completely agree. Anybody else before I get going? All right. So, I'd like to go through some applicable statutes. 411402 is the validity of consent of a minor for health services. Obviously applicable here. There's certain types of health services that minors can consent to, and certain types of scenarios in which it allows a minor to consent when they may not otherwise be able to consent. Can read through that statute there, but there's various different ones: emancipated minors, a minor professing to be married, a minor that's found to be separated from the minor's parents, professes or is found to be pregnant, in need of emergency care. So those are different situations where a minor can consent without the parental consent as well. So in that emergencies and special situations, health care provider can render or attempt to render emergency services. Consent may not be required if the minor does not possess the mental capacity, though, and I think that's important. That's a separate consideration. Obviously, they have to have the mental capacity to do so, even if they are emancipated, and does not apply to sterilization or abortion in this statute. That said, some case law we'll talk about later kind of conflicts with that statute to a degree at this stage in this point in time. 411407 discusses the immunity and responsibility of physician or healthcare facility. They may not be compelled against their best judgment to treat a minor on the minor's own consent. And so that's important to note with the change that we're proposing. The healthcare professional at the end of the day gets to make the decision based on their best judgment to treat a minor, even if it's under the minor's consent. And so that's something that we'll need to consider with any statutory changes, whether it would necessitate, in my opinion, a change to that as well. Legislative services is much better at that sort of decision making than I am. So I'm certainly not the expert in that field. Like I said before, can consent for emergency care, including transfusions, and necessary to prevent serious injury or harm. That part of the statute is one where I think an argument could be made for a SAN exam potentially. Anyway, I don't know that healthcare professionals would be comfortable with that determination at this point, just given the language of that statute, but arguably, if the minor is being perpetrated on by a parent and it's causing injury and harm, the healthcare professional could ostensibly argue that it is for the purpose of preventing serious injury or harm to that child. 411405 goes further to provide that healthcare professionals can render attempt emergency services or first aid and so on without compensation regardless of age. And so that applies to minors as well. Another situation where minors can consent is in family planning and contraceptives. If a minor professes or is found to be pregnant, they may consent to health services given in connection with prevention of pregnancy. Healthcare professional providing care in these cases of self-consent must provide counseling or refer the minor to another professional for counseling. And so that is in this statute. That may actually apply with our proposed change as well. We may want to consider something along those lines with regards to counseling. That said, through that process with CPS, and if criminal charges are brought, that certainly would be part of any follow-up from the state's end anyway, from my perspective. So abortion is another one, and that's really where the case law currently delves into these sort of minor consent issues. And so I wanted to start by talking a little bit about the history of legalization of abortion in Montana. It is protected under Armstrong v. State, it's a case from 1999, and it protects the right to seek and obtain a pre-viability abortion from a healthcare provider. It remains legal in Montana, and in November of 2024, in CI 128, an amendment to the Constitution was passed that makes the right to decisions about one's own pregnancy, including abortion, saying they cannot be denied or burdened by the government unless justified by a compelling state interest. And that compelling state interest part is something that we'll talk about in the case law when determining whether or not rights can be taken away from minors through legislation. And the reason that's important is because the consideration on the other side of the coin is, would legislation like we're proposing, would there be an argument that that's taking rights away from the parents? And so there's two sides to that coin here. And the case law on this kind of discusses both sides of that coin to a degree. And so it's important to note, though, now that in 2024, we do have the right to an abortion codified within the Montana Constitution. All right, so with regards to minors, first need to determine what is a minor. Montana Constitution Article 2, Section 14 provides the age of majority is 18, which determines that a minor is under the age of 18. That doesn't mean that statutes can't differentiate between a minor above and over the age of 16, as some do, and some criminal codes even differentiate between somebody under the age of 16 or under the age of 12 as well, but only for essentially the penalty phase of any sorts of crimes. So generally, as in the Montana Constitution, the age of majority is 18. All right, so there's two major rights that the Montana Supreme Court has determined apply to minors as well as adults. The first is the right to privacy in Section 10, Article 2 of the Montana Constitution, which reads that the right of individual privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. And as I'll discuss later, that has been determined to be a right held by minors as well as adults. The other is equal protection under the Montana Constitution in Article 2, Section 15. That reads that the rights of persons under 18 years of age shall include, but not be limited to, all fundamental rights of this article, unless specifically precluded by law, which enhance the protection of such persons. So essentially what that means is that, as it says there, minors are afforded that full recognition under the Equal Protection Clause, and all fundamental rights that an adult would hold as well. So Planned Parenthood versus state of Montana is the seminal case that deals with this sort of rights of a minor versus right of a parent to consent. It dealt specifically with abortion. In 2013, the Parental Consent for Abortion Act was passed. That was then challenged by Planned Parenthood. Ruling was given in the district court and was appealed to the Montana Supreme Court. Ultimately, the Supreme Court determined that the rights of a minor to control their body and destiny as protected by those previous constitutional rights discussed do apply to a minor, and that the Consent Act would violate the minor's rights by requiring consent of a parent for the minor to get an abortion. The state had to show a compelling state interest in that, and the Supreme Court determined that they were unable to do so. And so we'll discuss kind of what went into that decision, and the various considerations that the Supreme Court needed to make in coming to that conclusion. So within that case, as stated there, Montana Constitution affords significantly broader protections than the federal Constitution, and that's across the board, and that's an important constitutional consideration when it comes to the rights to privacy for minors or adults in the state of Montana. So anytime rights are discussed, oftentimes you'll see people try to argue it based on the federal Constitution, and the Montana Constitution is broader. So in constitutional law, state constitutions can give extra rights to individuals, but they can never take away rights that are given within the United States Constitution. And so you have to comply with all of the rights given in the United States Constitution, but as a state, you are allowed to codify rights within your Constitution that are broader than the scope of the United States Constitution. One thing that was stated that is important for our considerations here is that the constitutional rights do not mature, come into being magically only when one attains the state-defined age of majority, and that minors are protected by the Constitution and possess the constitutional rights that adults do as well. So under the 14th Amendment of the United States Constitution and Montana Constitution, Article 2, Section 15, minors are afforded the full recognition of the Equal Protection Clause, as I discussed before. That is a fundamental right of an adult, and the Supreme Court in this case discussed how that also is a fundamental right of minors. And the person of the age of majority have all the fundamental rights of the Declaration of Rights. And the only exception permitted is the rights are infringed by laws designed and operated to enhance the protections for such persons. And I think that's an important statement that was made in that case for our purposes, because for our purposes, we are trying to enhance the protection of children, of minors in these sorts of situations. And so if this legislation were to go through and be passed and a challenge was made to the language, the compelling state interest, if the argument was that we're taking rights away from parents to have the ability to control medical decisions for their children, the opposite argument would be that this legislation would be operating to enhance the protection of the minors. And so I think that's an important distinction that would need to be made if challenged. So I have a couple quotes that I thought were very pertinent from that case to our considerations here. This one, we conclude that minors, like adults, have the fundamental rights of privacy, which includes procreative autonomy, making medical decisions affecting his or her bodily integrity and health in partnership with the chosen healthcare provider, free from governmental interference. So essentially what they were saying is the government is interfering through the act by requiring consent of the parent prior to allowing the child to consent to the treatment for their own body if they are seeking an abortion. For our considerations, I think the same would apply. That anything that said that you have to get parental consent in order to get a SARN exam in the sorts of situations that we've discussed would be governmental interference and would not be a compelling state interest to not further protect children. I think that's kind of the crux of the whole thing. Went further on to say that decisions about intimate invasions of body and psyche must be an individual's decision, and in this case, a minor's decision. Ultimately, they decided that Consent Act infringed upon a minor's fundamental right to privacy because it conditions a minor's obtaining an abortion on parental consent or judicial waiver, which is something a minor choosing to carry her pregnancy to term would not have to do. Again, it's just referencing back to the fact that the minor should have autonomy over their own body when seeking this sort of medical care, and I think would follow through with the sorts of changes that we are proposing here. Not only the right to privacy was protected for minors, but they went on to discuss how the full recognition under the Protection Clause, and they enjoy all of the fundamental rights of an adult, including the right to privacy. And so, as I said before, in order to essentially restrict the rights of minors, the government has to show a compelling governmental interest. Interestingly enough, in this case, one of the governmental interests that the state tried to propose was that by requiring the parental consent prior to allowing a child to obtain an abortion was to protect victims of sexual assault. The Supreme Court, in 2 sentences, essentially said that's not how it works. They are already protected. And the reason that they're protected is because mandatory reporting laws already are in existence. And so basically saying we don't need the consent of the parent for this to happen. If the pregnancy occurred as a result of sexual assault, the medical provider is a mandatory reporter already. They will already have to report that. And it doesn't, getting the parental consent doesn't in any way protect victims of sexual assault. And so, obviously, our purposes with our proposed legislation is exactly that. It is to protect victims of sexual assault. And so, essentially, if challenged, the challenger would have to show that it's not a compelling state interest to take away the parent's right to consent on this sort of a case when an individual is potentially a victim of sexual abuse. So they discussed 41.3.201, where medical professionals have reasonable cause to suspect as a result of the information they received in their professional capacity that child is abused or neglected by anyone, regardless of whether the person suspected to cause the abuse or neglect is a parent or other person responsible for the child's welfare, and they have to report that matter. So that's our mandatory reporting statute. They also specifically noted that the record was completely devoid of any evidence that provides enhanced protection over mandatory reporting laws, especially given that some minors are being abused by parents. And so for our purposes, I thought that was interesting that they specifically stated that, we have mandatory reporting laws in place already to make sure that the appropriate authorities are notified of these sorts of things. Requiring consent does not in any way protect those minors that are victims of sexual abuse, especially in instances where they're being abused by their parents. And so I think the fact that the Supreme Court has put that in the opinion already would really help moving forward with legislation like the kind that's being proposed here. All right. So before I move on, any questions on Planned Parenthood, the case, how it may apply or may not apply to the legislation that we are proposing? Did that make any sense? I guess is my ultimate question.
Thanks, Brett. That was awesome. That made a lot of sense, even though it was in lawyer talk a little bit. I think you dumbed it down for us not lawyer people, but thanks for doing all that research. That was really helpful.
Absolutely.
I would agree it was really helpful. And now I'm a little intrigued on a side topic if we'll see abortion added back into the minor consent law based off of this Supreme Court case.
Yeah, I think it would be almost immediately struck down based on the ruling in this case. Because they would still have to show that same compelling governmental interest, which they were very clearly not able to show, according to the Supreme Court, in the Planned Parenthood case. So I think any attempt to do that would be a violation without an amendment to the Constitution itself, would be my take on it. Stephanie, you may have thoughts. I don't know. Haven't heard from her yet, so she must not disagree too much. I'm hoping.
No, I mean, I think this is such a delicate balance, and I'm kind of sitting back and taking it all in. But like, obviously, we respect parental rights, but in these cases, there has to be a mechanism for a child to be able to get an exam. It does seem like some of the statute and some of this case, I mean, the statute, I guess, backed up by this Planned Parenthood case, kind of supports the idea that, I mean, healthcare providers would be okay to do this. But I mean, I'm new to the committee, so I'm not sure what, hospital folks might think about.
Yeah. And parental rights is actually the next thing that I'm going to talk about to kind of show the other side of that coin a little bit. Anybody else? All right. If not, we'll move on to parental rights. All right. So 40-6501 discusses legislative intent regarding parental rights. Legislature recognized that the rights of parents to custody and control of a child are based upon liberties secured by the United States Montana Constitution's parents' rights to that custody and control of a child are therefore normally supreme to the interests of other persons. I think the operative word there is normally supreme to the interest of other persons. The other persons in our case here would be the minor. Went on to further state that the intent of the legislature is for the caretaker relative, and this is a kind of a subsection that talks about basically if you let your kid go with grandma, aunt, uncle, that they're granted the authority to consent to medical care for the child without superseding any of the parental rights regarding that child. In 41-7-102, this is the policy and guiding principles that was, I think, just passed in 2024. Let me pull that up really quick. I want to make sure I have that right for you guys. (2023) is when it was last, I believe.
Reference I'm seeing, Brett, in folio is 1993. Maybe that didn't get
Yep.
updated.
Nope, this one was 93. I apologize. It's the next couple that I'm going to be talking about that were more recently updated. In any case, it discusses the policy and guiding principles for the family. And below in sub little 3, says protecting and caring for children in crisis by providing intensive services to protect children who have suffered or are at risk of suffering serious harm from child abuse and neglect. I put that in there just because I think it's important to note that the legislature has essentially made that a priority and codified that to make sure that we're always trying to protect minors that may be at risk or are being abused or neglected. So interference with fundamental parental rights. The operative parts here is that all fundamental parental rights are exclusively reserved to the parent of a child without obstruction or interference by government entity, including but not limited to the rights and responsibilities to do the following: make and consent to all physical and mental care decisions for the family. That's obviously very important for our considerations here. And that was last codified in 2023. And so there has been a major push recently toward rights of a parent in our state. And that's why this is kind of a balancing act between the rights of the parent versus the rights of the child. And so that's a consideration that we have to have. Again, the challenge from my perspective, the legislation we're proposing would have to be that the legislation is violating one of these statutes regarding parental rights. And in order to do that, they would show that there's a compelling state interest to protecting the parental rights over the rights of that particular child. In my opinion, I think that would be a hard sell, given that the purpose of the legislation is to further protect children, especially when they are potentially a victim of one of the parents. And I would argue that the child's rights in that case supersede that of the parent. And that's essentially what most of the surrounding states that have this sort of statute, that's kind of the conclusion that they have come to, even when they do have specific parental rights statutes in place. So, with all that being said, as I said at the beginning, I think that due to the push toward further parental rights and autonomy, I think the more narrowly tailored that we can have this proposed legislation, the more likely our chances of being able to get it passed would be. But again, I think this is something that we obviously need to continue to discuss amongst the group, considering all different sorts of considerations and different situations that we've seen that this may apply to tailor our language so that we cover enough of the situations that we think need to be covered, but without it being so broad that there would be major pushback in the legislature. I do think, though, that Planned Parenthood really does help with some of the language that they put in that case. And the other thing I didn't mention is Planned Parenthood was appealed to the United States Supreme Court, and the United States Supreme Court denied certiorari on that case, essentially saying that they would not take it up in a short opinion. And I was going to put some language in there from that, but it didn't seem necessary. They essentially said, it seems like they got it right. We don't need any reason to take this up. They didn't, in the Planned Parenthood case in the state of Montana, they did not address specifically the federal law that may apply. In the federal cases, there were a couple referenced, but their decision was not based on the federal law. And so ultimately, the United States Supreme Court denied cert and said they weren't going to take up the cause. So as of now, Planned Parenthood from 2024 is the law in the state. And so that's what we have. And I do think that the language within that case bolsters our cause here with this proposed legislation. That is the end of my presentation. If anybody has thoughts, comments, questions, concerns, anything you've got, I'd be happy to try to answer. Honeycutt.
Thanks, Brett. So one of the things I was kind of thinking about as we started, and I know Emily and Brenda, they kind of had some concerns about the incest, right? And I think maybe to helpful when we start to think about this and talk about this is going back to the definitions in the law. The way incest works is kind of that like a plus sign, right? So it's descendants, grandparents, etc. up here,
Yep.
right? Parents down here. Then your siblings, whether they be step siblings, adopted siblings, etc., come on that sideways line.
Mm-hmm.
So I think that will cover, by using the definitions that are already in the law, will help clarify some of those. If grandpa's in the home or some of that kind of stuff,
yep,
we can cover it.
That's a great point. That's a great point. Whitney?
When I look at the legislation we had kind of or like our draft proposal, when we talk about, there was somewhere in there, and maybe it's not in this paragraph, but I thought there was something that the healthcare provider would have to attempt to notify that parent within, I don't know if we said like 24 hours or 72 hours, but I thought there was a time frame on it. That makes me a little hesitant, especially when we talk about those cases with incest. I mean, it makes me
And we
nervous
did.
in all cases, but specifically those cases, like this child came forward and we provided medical care, and now we're going to tell you that we did it within so much time later. That makes me a little nervous.
Yeah, and that was initially we had discussed kind of a time frame because some of the surrounding states do have a time frame, and I think that's why we ultimately landed on as soon as practical.
And there's
except
also
under sub 2.
There was also the exception that unless the parent or legal guardian was the suspected perpetrator.
Right.
Oh, okay. Okay.
Right. So the attempted notification is only if the parent or legal guardian is not the suspected perpetrator, and then again, only as soon as practical, so that there wasn't a time frame on there.
Okay. Do you think, is there a reason why, I know this is very different from the abortion laws, but they don't have that requirement in there? Is there a reason the team is really passionate about having that requirement in there, or not?
What requirement is that?
The notifying parents.
So I think that the notification of parents is throughout that statute as a requirement, not just in our subsection.
Okay.
And so I think it's just consistent. And in all of the other states that we reviewed that had this sort of subsection, there was always a notice requirement of some kind. And so I think, the legislature looks at surrounding states often to try to make sure that things are consistent within, bordering states and whatnot. And I think that's why more or less we ended up having at least some sort of notice requirement in there, along with the other exceptions that allow for minor consent. Most of those have a notice requirement of some kind as well.
Okay, because we would still have our mandatory reporting guidelines as well. So my thought is the mandatory reporting is that's probably not going to suffice the notifying parents, notifying
No, because
it'd be different.
Right, because the mandatory reporting is just to the appropriate agencies, right?
Right.
Mandatory reporting is not to parents. Emily?
So looking at the statute on MCA, the 411402, subsection D says that if emergency care is rendered, the parents, or legal guardian must be informed as soon as practical, but the other sections don't have that outlined in there. And if I recall, we talked about having it in there to help mitigate issues with the pro-parent rights movement that's happening, but I can also see where Whitney's coming from. And is it best if we don't always tell the parents that kids are coming in for these care, because we unfortunately are seeing issues where kids suffer from mental health and have a suicide attempt, and then their parents beat the crap out of them before they come in for medical care. And so, like, what is that fear at home for these kids if this gets disclosed to the parents? And so, are we actually creating a more harmful situation by having that language in there than helpful?
Yep. Yeah, and to your point, with regards to sub D, that was, that was a consideration we had, just for consistency's sake, as well as, anticipation of potential challenges. If it's consistent with the remainder of the statute, I think that's always helpful, in passing any sort of legislation. But again, I'm not a legislator, so I'm not sure what they're thinking a lot of the time. Anybody else? Stephanie, I'm gonna put you on the spot. You got anything illuminating?
I mean, I have thoughts. The soon as practical notification. I mean, in certain circumstances, couldn't that be like, say you have an incest or a family abuse case where you have a parent or guardian who's the one who's the perpetrator of the abuse? Couldn't you use that as soon as practical notification? Like, if there's some sort of CPS, your MDT is working on it, and you have like a custody issue going on where you're trying to get some sort of temporary authority or something, given the fact that the child's in an abusive situation, wouldn't that give some of the leeway needed for notification? And then wouldn't the notification potentially then go to CPS?
Yeah, I mean, I think it would. Um, but as written, or at least the intent is, if a parent or parent's legal guardian is the suspected perpetrator, no notification is necessary under those
Uh,
circumstances. That's the intent. And again, the language obviously is fluid here. Um, but no notification would be given in those sorts of situations, or be
Okay.
required, I should say.
And then the concern for the expanded definition, like if it's a sibling or things like that,
Hmm.
where you won't have a supportive parent,
Hmm.
like how do we address that in the legislation?
Yeah, no, that's a good question. I think Captain Honeycutt made a good point about, um, suspected to be a victim of incest, right? Because that statute does have the broader definitions. It does define, what that would entail, and what individuals would fall under that. Um, maybe, maybe we need to add that list to this legislation. I don't know. Maybe that would be helpful.
Like the
Um,
descendant, those
mhm.
ancestor, those things to it. Yeah.
Yeah,
Because I don't think we can add just the word incest. I think it requires too much legal analysis on the spot.
yeah, no, that's a great point. I think that's a great point. Anything else before I jump to Captain Honeycutt?
I mean, I guess the one thing that's in the back of my mind is that we have this exception carved out for emergency. And I guess when I think about sexual assaults, and I guess what qualifies as an emergency, I'm not sure how far you can play with that, but I do think that like another way to sell this is, if you have a child who is for whatever reason afraid to disclose to parents, but like wants to get this, has been a victim of sexual assault and wants to get this examination done. I mean, I have a daughter, like I wouldn't want my daughter to not get an examination and potentially collect evidence just because like she'd be afraid to notify me or, her dad about something that happened. And so there is an emergency aspect to it because, which is an exception we've already carved out and we can maybe piggyback on because the acute nature of the examinations make it something that needs to be done relatively quickly. And in
Yeah,
that sense,
time's of the essence, right?
exactly. And in
Yeah,
that sense, it is somewhat like emergent, like it's an
yeah,
emergency in a sense to be able to get those examinations quickly.
yeah. And I think the problem, just in listening to those, on the committee in the medical field, is that almost requires them to make that legal leap, right? They have to then say, well, would this be considered an emergency under the law? And they're generally just not willing to, and I don't blame them, not willing to make that leap on their own without it being specific. And that was kind of point of trying to get some legislation like this, is so that we're not asking medical professionals to be legal professionals and try to make that legal leap to, yes, this is emergent, I guess.
Okay, that makes sense.
Captain Honeycutt?
Thanks, Brett. So one of the things I want to remind folks at 2 o'clock in the morning when this happens, we're worried about notifying parents if the parents are the suspects, right? They already know that their kid's getting done because I promise you they're having a discussion with me they don't want to have. So the kid is safe. And if the dad is the perp, mom is trying to protect dad and not kid, we've had very good luck working with CPS to make sure that that child is safe and taken care of. And if need be, then they take over the guardianship. And when that happens, then that helps mitigate that with the doctors as far as whether they can have medical treatment or not. And CPS will step in and say, for the best well-being of the child, they can do that legally and take over. Eases up on the doctors a little bit. The kid stays safe. And then, of course, mom and dad both are going to end up visiting with me and probably not getting to go home, or that kid's not going to go home. As Emily had mentioned, like when they get beat up before they come in, as soon as they get to the hospital and they've been beat to hell before a mental health evaluation, I promise you, I'm the next phone call and we're there. So that kid is our main priority to keep them safe and protected. And that's what's going to happen.
Yeah. And I think that, I guess on the other side of that is, without legislation like this, you then are, I guess, relying on each of those individuals to take the right steps, right? And I'm not saying that you wouldn't as law enforcement, but there's certainly situations where CPS is called and they don't do what we would hope they would do in a situation. They don't get involved. They don't remove necessarily. And if you have a situation with a 17-year-old that comes in, there's no apparent physical marks or anything like that, and the report is that they've been sexually assaulted, that wouldn't necessarily trigger all of those steps and those individuals becoming involved. You know what I'm saying? Without legislation like this, is my thought. Christina?
So I'm wondering if we couldn't put in some, and I know nothing about this, so put in some wording that expands. The problem with the word perpetrator is that the situations that we have, we have it covered if the parent is a perpetrator. That we have places we can go if the parent is a perpetrator. If some other word could go in addition to perpetrator, like, that means, that somehow the custodial person is putting the kid in harm, some other legal phrase that could go in after that to be more inclusive, maybe that would be more protective, and enough for medical to act on. Because I think perpetrators, that's one scenario, but that's a scenario that we have pretty well taken care of. Does that make
it does. Something like perpetrator or enabler, is kind of what you're getting at, I think, right? I don't know. That's the problem. The more broad you make it, the more potential challenges there are to it, I guess.
I'm talking
But I
about
understand
when
what you're
the kid
saying.
is not safe. If we call the parents, we have put the kid in harm's way.
Right.
That whatever that harm from custodial, suspected harm from custodial, there has to be a shorter legal word. This is your life.
Yeah, I know what you're saying.
Christina, are you saying something? Do you guys all see the draft language that I took back the screen control? Sorry, Brett.
No, you're fine.
So the draft that you all had looked at in December and then February said, unless the parents, or legal guardian is the suspected perpetrator, or or the healthcare professional believes that notifying the parents would put the child in harm, the parent, legal guardian would put the child in harm. That's what you mean, Christina?
That is what I mean.
So they're not
And
the
I-
perpetrator, but notifying them could cause
Right,
harm.
they're not the perpetrator, but that there's going to be a negative consequence, a significant negative consequence to the child. But they're not the perpetrator.
Yeah, something to the effect of, or if the health professional believed that notification would place the child in danger of abuse, neglect, harm, however you wanted to state that. Yeah, that may cover it. That's a good point, Christina.
That makes me feel better, Christina.
Yay, me too. Go.
Yeah, that's the goal, right? That's why we need all these minds together.
I'm going to see if I can pull out a Word version to just workshop something for you while we're here. Other discussion or questions, though?
I guess I would like to ask the committee, it seems like when we had our last meeting in December and February that there was some kind of hesitation on the team of moving forward with, something like this. Are we feeling similar to the way we felt back then? Are we interested in moving something forward as a committee? Anyone have any thoughts they'd like to throw out, or thoughts that have changed in the last few months or after this presentation?
I would just say I think the biggest concern was the push toward parental rights. I know that was Celine's major concern. But I really do think that the holding in Planned Parenthood, in my view, alleviates a lot of those concerns, because they were willing to take that leap to say that, there's no compelling state interest to not allow a minor in those situations to consent. So from my perspective, I think that it really helps us out. And I think, I mean, you all know, obviously I've been talking about it for 45 minutes. I think legislation of this sort is so needed, given the situations that we see.
I think there was also a concern that the AG's office said that this would maybe not be something that they would be in support of over the last few meetings. And is that changed? Has like that condition changed at all? Are they still pretty solid on the fact that we don't need any amendments to this statute, and they think that it already covers sexual assault exams? Has there been any movement there?
Our thoughts remain the same. So if you guys want to pursue legislation, you're welcome to, but it's not in its current state. It's not something we'll support at this time. And like I said in our last meeting, we don't recommend moving forward with it.
Emily, would it be possible to get, I don't know, a written reason why? I guess I've yet to hear a reason that it wouldn't be supported by the Attorney General's office. Other than they think it's, I guess, already covered, is kind of what I took from last time.
I can look into it, and we can talk, and we can have some offline conversations too. But at this time, and I think Brett, you also talked to Celine. But if you're interested in revising the proposal, the legislative proposal, we're interested in looking at that too. But right now, like, that's where our office stands.
I guess my question was more towards, what sort of, I understood that the office would reconsider with revisals, but I guess I don't understand or know what revisals would be looking for, I guess. But yeah, we don't have to have the discussion right now. That's just kind of my question.
Yeah, and I mean, to be completely honest, I'm not a lawyer, so I don't have the same experience, and I relied a lot on Celine. So I'll talk to Stephanie too after this meeting, and we can talk about it. But I
Sure.
mean, that's still where we're at. I
Yeah.
would say, and you guys.
I don't mean to put you on the spot, Emily, at all.
No, that's okay. You guys are also you guys can bring legislative proposals yourself as a committee. Like you don't have to have the support of our office. So
Sure. Certainly. I appreciate it.
Yeah, and Emily, though, it'd be great if we could know what the objections are, because maybe it's something that we're not thinking of, so that we could better craft a more thoughtful, whatever we end up with would be great to have a little really specific input from what the AG's office, is thinking about this. If that's
yep, I get it. I'll have some conversations and we'll try and figure something out.
So we might be at the public comment portion of this agenda item. Unless anybody has any other thoughts or questions or discussion you'd like to have before that, based on Brett's presentation.
Just wanted to say thanks again for doing all the research and taking the time to do that presentation. That was really helpful. So thank you.
Absolutely. Thanks.
Okay, so we'll call for public comment on this portion of the agenda related to minor self-consent to sexual assault care. If you would please click the raise hand button at the bottom of the screen if you have a comment you'd like to make. And just a reminder to please spell your name for the record, identify yourself, and if you represent an organization or just yourself as an individual. And the first hand raised is Kelson Young.
Good morning, all. Can you hear me? Great. Hi, everyone. My name is Kelson Young. That's KELSENYOUNG. I have the privilege of being the executive director of the Montana Coalition Against Domestic and Sexual Violence. I was able to speak to many of you last meeting. So for those of you I don't know, a little bit of context, we are the statewide association that works on behalf of victims of domestic and sexual violence and other related crimes, as well as our member programs. Nice to see you, Christina. And on that note, I have some thoughts I'd like to share with you about this minor in consent proposal. So I thought I'd start by just reiterating a couple things that you just heard from your fellow committee members that in regards to my testimony are very important. Number one, you are an independent entity attached to the Attorney General's office, but you have the ability to request and move forward legislation on your own. And we are strongly urging you to do so. An entity like SARN is exactly set up for this purpose, which is to review the system, find the gaps, and come up with solutions. And the reality of this particular issue, as you've seen, is that it is a very contentious issue between parents and minors' rights. And we have lived in that space for a long time. And so I understand that it's difficult. But you're asking an attorney general who has generally led himself to be very conservative on this issue. And so I think it's a long shot that the attorney general's office would introduce and support a piece of legislation like this. I think ultimately you will find that there will be a much more bipartisan approach within the legislative session. So I do think that as a proposal, this would gain bipartisan support. doesn't necessarily mean that the Attorney General's office is in the position to publicly support in the same way that others would be. So you do have that ability to put forth this legislation regardless of his position. While I appreciate the Attorney General's office staff very much for their willingness to consider it, I think it's important to just reiterate that you do have that ability. We strongly support this concept. As you've heard and validated for us, this is a real issue on the ground. I do have some concerns about how you were considering limiting it, primarily based on my lived experience as a person working with sexual assault victims. We talked about incest, and the problem with incest sometimes is how it applies to dating partners. So I was a CASA advocate, which is court appointed special advocate for minors. And I often got the cases where it was a sexual assault case of, 14 and under. And more often than not, it's a mom living with a boyfriend, and the boyfriend is perpetrating sexual violence against the minor children. So my question for this team would be, how would what you're considering in terms of limiting apply in those situations? I agree with other committee members in terms of concerns around siblings, grandparents, but sometimes those biological relationships are covered more appropriately in our criminal statutes. And it's the boyfriend where I often see mom being the most offensive. I had CASA cases where mom never backed down from believing the boyfriend. And so, unfortunately, in those circumstances, there is a lot of concerning loyalties, I will say, in terms of how those cases show up in the system. So I guess my concern would be, if you limit it, which I understand all the reasons for it, what are we going to do for those kids who are actually in the most danger? People are in more danger from a non-biological parent oftentimes in these circumstances. So in that regard, it feels like we're leaving out the most marginalized, if you know what I mean. So I think it's important that we continue to consider, like, politically what would be feasible, but we are ready and willing to help fight this battle with you. I will say that our role is very much to advocate within the legislative session, and so we hope to be in partnership with you as opposed to having opposing opinions on different things. So I guess that would be my concern, is we would love to support this if it moves forward. We're concerned about the parameters around who this impacts. And, thank you so much, Mr. Aragoin, for your presentation, because it really does summarize so well the reality. And I think part of why we don't have the answers we need from the AG's office is because it's still very much about what ifs. But if we have this legislation, it will close that gap. It will leave medical providers in a better situation to be able to do the right thing in the moment. And more kids who are in serious danger right now in our communities will be protected. So I strongly ask you to consider moving forward with this legislation. Send it to Law and Justice, and we'll be next to you along the way. Thank you.
The next person to be called on for public comment is Mary Pat Hansen. Try that again.
Now, can you hear me?
Now I can hear you. Thank you.
Yeah. I am Mary Pat Hansen, so MaryPatHansen. And I have so many thoughts. I'm going to start with, at one point during a different committee meeting, the issue came up. If you put this issue before the legislature, could it backfire? And the outcome be the proposal is not taken as written, but instead a requirement is made for parental consent prior to an exam. I don't know that that could happen, but I'm saying it out loud that it is one of my concerns that you all who have way more experience with the legislature than I do, I would appreciate you considering and thinking about, because I want to echo something that I think it was Stephanie was talking about. and she made a comment, if her own child wanted care, she'd want her own child to be able to consent to this exam. And perhaps the current laws allow for that. And I think the sort of grayness that you all were wrestling with in your conversation allows for, at least at this point, certain providers to provide care for kids at the time that they are requesting it. And as the current proposal is written, I felt delighted if it were to move forward with Christina's recommendation to have a provision that is something along the lines that unless the healthcare provider has concern that the notification of the parent or caregiver would cause harm to the child. If you all do feel confident in taking this forward, at least putting that provision in allows for some critical judgment in the moment for all the unforeseen circumstances. I don't think you can just be like, if it's just incest. I think there are other reasons that it could cause harm to a child to inform their parent. I know that somewhere in the medical release laws in Montana, there is a provision that allows for us to not release medical records if it could cause harm to a child. And we rest on that a lot here at First Step, not releasing a record because we don't know what the ramifications would be if we release that record. And so having something in there that allows for the judgment of the institution or the healthcare provider to make a different decision. I think those are all my comments. Thank you guys for it's so complicated, and I appreciate you guys wrestling with it. I guess I'm just cautious of us making a requirement that could actually inadvertently cause some harm for children.
Last call for any other public comment. Please raise your hand if you'd like to make comments at this time specific to minor consent for care. There are no other hands raised at this time. Committee, do you have further discussion, comments, or questions that you'd like to consider?
I'd just like to, I'm so grateful for the public comment. It really is so helpful. Thank you, Kelson. Thank you, Mary Pat.
How do you feel about next steps on this topic? What do you think you'd like to do? Captain Honeycutt?
Thanks, Hope. I think we probably better talk about this a little bit more and maybe make a focused event just on this. Take a look at the individual laws, kind of like we talked about with incest. And as Kelson had said, we need to take some of the definitions from whether it be sidewalk, sexual abuse of children, all of the things that we already have currently in the law. We need to put those definitions in front of the committee. So when we sit down and look at what Brett had put together, maybe we can try and clean this up a little bit. And I would agree. I think we still need to try and push this forward, even without the support of that office. It's a very important topic and it needs to go forward.
Others? Yeah, Brett?
Yeah, I was just going to say, I agree. I think kind of roundtable on this and potential language is super important. I don't know that I put that together, Captain Honeycutt. I think it was kind of a collaborative effort on that language, but I think more collaboration is absolutely necessary. I mean, like I said early on, we all have different perspectives and think of things that others don't, and so I think one more time, at least, of everybody going through it and trying to figure out what the best language could be would be very, very beneficial for us.
Any other thoughts related to that? I think I'll throw out a concept of, oh, Whitney, go ahead.
I was just going to say, I can take some time to think about in the last couple of years of experience providing forensic medical exams of what kind of situations have popped up. So we can think about if, for me, if these laws were in effect then, how would that have changed the care that I gave or the care that I didn't give? Just those kind of situations to make sure we're thinking of all the things that, all the situations that could arise.
So the suggestion I was going to make was, so if there's interest in having another scheduled meeting and discussion specifically on this topic, looking ahead to say sometime in June, and giving me time to work with Brett and Stephanie and others about an updated version, maybe of what you saw in December and February, to the point that Christina made about whether notification could cause some other kind of harm, and that being an exception, not just if the parents, or legal guardian was the perpetrator. And also considering a version that would take that emergency care provision and adapt that as an alternative way to look at this, because that came up a couple of times today as a potential alternative. And so maybe bringing those two things back to you to look at side by side and think about some more at, say, a June meeting. Whitney, I see your hand up.
I was just going to say, could we also revisit what the states that surround us laws are? Because those are going to be probably brought up in front of legislation. So like North and South Dakota, Wyoming, Idaho. Because like Brett said, they try to, mimic state laws in neighboring states.
Mm-hmm. And I did pull that reference we used, I believe it was in December, back up today, and was just quickly looking at the states around us. So there were 20 some states. I forget if it was 22 or 23, and I didn't count them today. But of our neighbors, our immediate neighbors, South Dakota has a provision that the physician, hospital, or clinic shall take reasonable steps to notify a minor's parents or guardian that an exam has taken place unless the parent or guardian is the suspected perpetrator. Wyoming says if a minor reports an alleged sexual assault and the minor's parents cannot be located promptly with diligent effort, the minor may consent for a medical examination. North Dakota was the only other statute that had something related to this. Idaho did not. And I didn't note anything for Washington or Oregon either. But North Dakota just said that a physician or other healthcare provider may provide emergency medical care or forensic services to a minor who is a victim of sexual assault without the consent of the minor's parents or guardian. So that was North Dakota's language. If you look a little further south, Colorado requires that a provider must make a reasonable effort to notify the parent or guardian or any other person with custody or medical decision-making authority prior to commencing examination or treatment. And if the parent or guardian or person with custody or medical decision-making authority objects to treatment, the provider may examine and treat the minor, but the provider must make a child abuse report pursuant to Colorado's mandatory reporting laws. But I can send that out again. That's not a problem.
Hope, I did find in Washington State's legislature that minors are able to consent, so I'll send you that link. It was effective in 2024.
Oh, great. Thank you. Yeah, that might have outdated the roundup I was using last year. Yeah, thank you. Other comments or questions? Okay. If we look into November, November, gee whiz, what part of the year am I in? If we look into June together, Are there any particular weeks that are clearly no-goes for anybody? For instance, the week of June 22, I know is bad for me and Brenda, and Whitney. We have a thing going on that Tuesday, Wednesday, Thursday. Typically, I've found Mondays, Thursdays, and Fridays are better for the majority of folks, with Thursdays and Fridays being the best for most. Are there any Thursdays and Fridays in June that are real no-goes for anybody other than the 25th?
Hope, I have a trial that starts, I think I have to be like that week before, that week of the 15th. I'll be unavailable probably that Thursday and Friday. So if it could be before that in June, that would probably be preferable for my schedule.
Okay, so could June 11th or 12th work, Stephanie? Okay.
Yes.
If we look between June 4th and 5th or 11th and 12th, were you going to say something?
Yeah, I've got a conference on the 4th and I'm out of town on the 12th, and then I've got a subpoena the 22nd through the 26th.
We've narrowed to the 5th and the 11th. Sounds like. Seeing a thumb up from Captain Honeycutt. Okay. So I'll check our calendars here. I have not done that. And I'll look at those two dates specifically if I can't come up with a good option between the two of them. Are you feeling time-wise? Do you want an hour and a half, 2 hours? What are you thinking you need to have a good discussion? A couple hours? Just reserving that space, and then if you're done, Captain Honeycutt says 3.
I think any more than 2 hours on one topic, our brains start to kind of melt.
Okay.
And from my end, the 11th would be preferable to the 12th, to the
5th.
5th.
Okay. All right. Well, thank you for looking at your calendars real quick. Going back to today's agenda. It's time to call for public comment on any matter within the SARN committee's jurisdiction. At this time, anything that was not on the agenda today, but still within the SARN committee's jurisdiction, if you would like to make a comment, please raise your hand at this time and we'll recognize you and allow you to speak. Give it a minute here to see if anybody would like to raise a hand. Sometimes flipping through the cell phone looking for the hand button is a challenge. I'm not seeing any hands raised. And so any other committee discussion or consideration needed right now, other than we'll get this June meeting set up. I'll work with Brett, Stephanie, and others as needed to get a couple of drafts available to bring to that June meeting to consider. Whitney?
Sorry to keep putting my hand up, but is there anything you need from the team for next Thursday's LJIC meeting?
Oh, great point. Thank you for bringing that up. Sometimes I lose the forest for the trees. So with Law and Justice next week, Whitney testified last time and provided comment in March. She's set to schedule, pardon me, to testify in a trial the day on May 7th when Law and Justice meets next. It does not look like on the Law and Justice Interim Committee agenda that they're expecting a presentation of any kind from DOJ or SARN on the topic. It looks like their staff member will go through the bill draft with them and then they'll have an opportunity for public comment. So I'm planning to be there, offer up the letter that you all put forward at your February meeting in support of the concept. And anybody would be welcome if you'd like to participate and provide formal public comment as a SARN committee member. Is anyone interested in doing that? There's a registration requirement if you want to participate on Zoom that I could help you connect with. Or you could submit written comments individually if you were interested, and I can help you connect with that option too. Otherwise, I can say the committee continues in its support of the proposal and with the removal of the reference to the IAFN, which no longer exists.
Was that
Also on
Thursday
that,
or
Hope,
Friday? Hope.
It's Thursday the 7th at 11 a.m.
Also about the IFN, just so the committee knows that just because the IFN has dissolved does not mean that there's no more like education or training curriculum for forensic nurses. That has been absorbed by the ENA, which is the Emergency Nurses Association. I totally agree with Hope about not putting any specific titles in the legislation, but just so you know, it's not moving forward a free-for-all. Like there's no formal training still there, just under a different organization.
And to
And to
piggyback
add,
off of that, our scope and practice is regulated by the ANCC. So there are still other agencies that are responsible for kind of giving us our parameters for the work that we do.
and there are other entities such as a university in Texas and I believe Pennsylvania as well that are offering the didactic course online in a different way and format than the IAFN's totally asynchronous course was offered. But that is still available in addition to the fall course that the Montana trainers offer on Zoom in coordination with the Department of Justice. So we still have educational opportunities available without that IAFN course being in existence. So thanks for bringing that up because that has been a bit of, I don't know, Whitney or Emily, how you would like to describe the experience of watching the IAFN go through this and what has happened with them, but it's been a wonderment for people, I guess is one way to put it. So other discussion. Anybody else interested in getting the information about how to participate in Law and Justice next Thursday? And I'll send it to you, or I can just simply send it to the whole committee if someone's interested. You can think about it between now and then. It does require you to sign up for the Zoom at least 2 hours in advance. I'd recommend, giving it at least a day in advance if you did want to participate. So you have to register for an account with Legislative Services through their website. It's not hard, but it is a couple of step process. So don't expect to be able to hop on at 10:59 and say, I want the Zoom. All right. Well, Brenda.
Hope, I think you have obviously more experience and a lot of other people have a lot more experience. So I guess I would just reach out and say, do you think it's important that some of us be there or at least chime in with comments? Do you think it would be helpful? And if you do, how many people do you think should make comment to support it?
Last time Whitney and Ben Ulick commented, Ben was on Zoom, Whitney was in person. I never think it hurts to have a couple of the real folk decision makers there, in addition to a staff person like me available to answer questions. I never think that's a bad idea. But if you're not available, you're not available. And, that's understandable. You have the formal letter. But I think, if you had one or two, that'd be a good number.
One of the things that came up in the last committee's discussion was the responsibility of hospitals. Do we know if the Montana Hospital Association has stepped in and done any communication with that committee about this bill and their role and how they do support programs? Or do we expect that line of questioning again?
Emily, I can't answer that question. I don't know if MHA has done any outreach or not. I know that we as DOJ forwarded the information that Ben Ulick provided after the meeting, as he said he would. And the the direction was if they had further questions to reach out to Ben directly if they wanted to follow up on the information he provided. But I don't know if any other communication has occurred or if it would come up again. I just don't know.
Okay, thanks for that update.
Mm-hmm. Other questions, conversation? Okay. Well, as always, thank you for your time and thoughtful discussion. You guys are a terrific group. Thanks, Stephanie, for being here today. We like to end on a quick round robin wrap up, key takeaways of the day. Would you guys like to go through that, or do you want to just say sayonara for now? Forced group communication by Hope Stockwell. Captain Honeycutt, was that you raising your hand to say I'll go first, or let's get out of here?
Nope, we could go either way. Hope as far as learning everything, every time we get together, I learn something new, challenges the brain, and the public comment coming in, I think, was great, helping us know that we're on the right track and that it matters to people other than just us. So I'm glad to do it.
I just wanted to verify she's actually got a.
Thanks, Captain. Stephanie, I'm going to turn to you next.
Sure. So, I guess a takeaway that I have is there's a lot of people on this panel and even that are paying attention in the public realm that have a lot of value to add to these important topics. I think that my personal takeaway is that we've got some work to do and some stuff to look at in terms of drafting. I've got my list for what we're going to revisit in June, and I will look forward to starting work on that.
Appreciate that. Thank you. Emily Mangus.
I really enjoyed the presentation that Brett provided, like the information about what happened at the Montana Supreme Court with Planned Parenthood versus the state of Montana was really informative, and I'm really intrigued to see where that goes. And I'm glad to hear that the United States Supreme Court didn't pick it up, and that we can sort of use that as a means to move forward.
Christina.
I love this team. That it was a great presentation, Brett. It was really helpful. And that, that we're walking away with, this is one of the meetings that I'm walking away with a lot of optimism from. And right now that is just so great to have. So thank you all.
Thanks, Christina. Brenda.
Yeah, just echo what everyone has said. Thank you, Brett, for the presentation. It was very helpful. Thank you, everybody else, for your perspectives. The diversity of perspectives is awesome. And I love that we just bounce things off of each other. The experience of the nurses who were actually seeing the patients, you guys, it's really valuable, your perspective. And then again, the public comment, just appreciate Kelson and Mary Pat and all the members of the public that are interested in this and that take the time to watch and give us guidance. So it's great to be with all of you. Thank you for letting me be part of it.
Thanks, Brenda. Jamie.
Big thank you to everyone. The presentation was awesome. I learned something new every time, and it kind of sat there and reflected on the casework that we get, the different scenarios, and everything that was brought up by Whitney and Emily. Those type of case scenarios were running through my head on how you got permission and the steps going into that and the law behind it. So I learned something new, and I appreciate the public comment. It's a great meeting.
Thanks, Jamie. Brett.
I mean, I think you guys have all heard me talk enough today. But one thing I will say is, we put together that legislation kind of collaboratively, but there's absolutely no pride in authorship from my end. You know, any suggestions I think are so necessary and welcome, and hopefully we can all work together to get the best version possible and make an informed decision on what we want to do going forward. So thanks everybody for your comments and thoughts and questions and all that stuff.
Thanks for the presentation today, Brett. I really appreciate that. Whitney.
I could say the same as Brett, that you probably heard me talk enough today. So thank you for, the presentation and the meeting, and like Christina, feeling some positivity and optimism following this meeting, which I normally do every time we meet. So we're a great team.
Thanks, Whitney. And Mark.
Well, like always, I feel like I'm drinking from a fire hose, so I learned a lot today. I appreciate everyone's comments and looking forward to the meeting in June. And good luck with the Tooth Fairy tonight, Hope.
Thank you. I'm gonna have to set a trap to catch her, I think, this time. Yeah. Appreciate it. Well, hope you're all well. Have fun plans ahead of you, finding some R&R, and I'll get the information out to you for a June meeting and also keep you posted on next week's Law and Justice Interim Committee. Thanks for your time, everybody. Appreciate you.
Recording stop.